Hello, I'm Jan Paynter, and I'd like to welcome you again to our program, Politics Matters. We began Politics Matters focusing on the idea that people are their principles and that our politics therefore should reflect that concept, and yet, as we all know, it frequently does not. Today we begin a special program on the amendments to the Constitution with the idea that it might prove useful at this moment in our history to consider why they were written and, of course, what they are, how interpretations of individual amendments have evolved over time, and which ones are particularly relevant. Certain amendments, such as the First Amendment guaranteeing free speech, freedom of press, religion, etc., and the 10th Amendment examining states' rights, are frequently referred to in media without offering people any discussion as to the historical circumstances under which they came about and why they were adopted into law. Are there amendments to the Constitution which could be better understood and discussed in order for all of us to comprehend our laws, rights, and privileges more thoroughly? Today we have with us Professor Frederick Schauer, David and Mary Harrison Distinguished Professor of Law at the University of Virginia, where he teaches courses in constitutional law, evidence, and philosophy of law. Professor Schauer holds an AB and MBA from Dartmouth College and a JD from Harvard Law School. He is also Frank Stanton Professor of the First Amendment, Emeritus at the JFK Kennedy School of Government, served as academic dean and acting dean, and also taught courses in evidence and the First Amendment at Harvard Law School. Welcome, Professor Schauer.
Thank you. Delighted to be here.
Before we begin, tell us, if you would, what motivations or events brought you to the study of law? In essence, what law and politics mean to you?
The first one's a little easier than the second. I think, as with most people, I arrived at undergraduate education with only a dimly formed idea of what I wanted to do with my life. Once I realized that my initial preference for medicine was not for me intellectually or in any other way. My interest in things verbal, my interest in the forms of argument and all of that led me to think about law. So it's something I've been focused on since I was about 20 years old, I guess.
To begin our discussion of the amendments to the Constitution, give us, if you would, some of the history behind their inception.
The first 10 amendments, the ones we call the Bill of Rights, were part of in a way, compromise enacted or adopted or agreed upon at the time of the original ratification of the Constitution in 1787. Some people wanted rights to be included in the Constitution. Some didn't want them to be included in the Constitution. But the Bill of Rights, 1791, 4 years after the original Constitution, was part of this compromise. Some people agreed to go along on the assumption that shortly thereafter there would be a Bill of Rights. The important thing to remember about the Bill of Rights is that it was originally intended solely as a restriction on the federal government and not as a restriction on the states. Freedom of speech, the rights of criminal defendants, freedom of religion, and all of this were originally thought of solely in terms of federal power. The states could do what they wanted. States could establish religions, restrict speech, or do anything else. That did not change until the 14th Amendment in 1868 and subsequent judicial interpretations, which made clear later that the Bill of Rights, by use of the 14th Amendment, also protected rights against state encroachment. But originally, it was just a limitation on federal power. It's only largely in the 20th century and now thereafter that they've been understood as restrictions on the states as well.
That's what was going to be my next question, is how has that evolved and changed? How do we think of the now?
I mean, now we think of it as restrictions both on the states and on the federal government. As I said, this is largely a function of judicial interpretations of the 14th Amendment, which protects life, liberty, or property without due process of law. The courts have said that the protection, virtually all of the protections of the Bill of Rights are incorporated, the technical term, incorporated in the Due Process Clause of the 14th Amendment. So since more or less the 1920s or 30s, we have understood, and the courts have understood, that pretty much the same protections apply against the states as apply against the federal government.
Okay. In looking at the freedom of press issue, we are all very alive right now to an issue which has been much in the progress. Albemarle High School had a young woman who wrote an editorial in which she suggested that perhaps student athletes didn't need to take PE. The principal of the high school had some objections to it, as everyone knows, cited some typos, some various other reasons not entirely disclosed. The paper ran minus the article, and the young woman was alleging that her right of free speech and freedom of the press was violated. There have been back and forth editorials to the progress. Again, one gentleman wrote in and said, well, actually, the school functions like an employer, and therefore there is absolutely no reason why, since they have dress codes and other rules, we can't they cannot restrict the student's speech. John Whitehead recently had a piece in which he talked about a dangerous, increasing sense of authoritarian, which is creeping into our schools, and that is a microcosm of what's going on in the country. So, having said all that, what do you think, pro and con, about this issue? Does the principal in the school have a point? Does the editorial writer have a point?
Well, there are the First Amendment itself, as with most of the amendments on most subjects, doesn't answer the question. Might be useful to point out that the United States has roughly the shortest constitution in the world. And by virtue of being short, it's vague, it's open-ended, it doesn't answer a lot of questions. The U.S. Constitution is about 12 pages long, Constitution of South Africa about 110, Brazil about 240. So we have a constitution with very little detail, and it's up to the courts to fill in the blanks. On the question of freedom of the press, things are no different. The blanks have been filled in terms of student speech and student press only 4 times. The Supreme Court has decided only 4 cases dealing with student free speech rights. One was a case called Tinker versus the Des Moines School District in 1968, protecting the rights of students to wear protest armbands in class. There have been 3 cases since then, and only 3 since then. One upholding a school's right to discipline students who used off-color language in campus, school political campaigns. One very recently upholding the right of a school to discipline students who engaged in, again, drug-related protests. Bong hits for Jesus was the actual sign that the students displayed. And in between those, there was a case dealing with student newspapers and dealing with the student press, in which the Supreme Court said on the facts of that case, that the student press or student newspapers in that case were largely part of the curriculum and the ability of school administrators to restrict the content of student newspapers was not dramatically different from the ability of school administrators to give students good grades or bad grades, depending on how they performed in written exercise. Now,
do you think
whether,
I'm sorry, go ahead. I was just thinking, is this an issue, do you feel, that is going to continue to come up? Because it would seem that way.
It comes up a lot in the lower courts, and the Supreme Court is very reluctant to decide cases dealing with it. It's one of the most commonly litigated issues in lower courts. That is, student speech, student dress, off-color T-shirts, Nazi T-shirts, Klan T-shirts, sexually suggestive apparel, student protest, and so on. The Supreme Court, as I said, decides roughly one case every 10 years. So it remains somewhat of a gray area. The lower courts are all over the map. If it were at the university level, it's clear that the student press would be treated as the press, even in a state university. There are also Supreme Court cases saying that the university-based student press has most, if not all, of the protections of the independent and private press.
That's interesting. So younger people are actually penalized.
I don't know what penalized is not a word I would use in this context.
Okay.
There is a distinction in terms of all dimensions of academic freedom between the primary and secondary schools on the one hand and colleges and universities on the other. There are things that I am constitutionally protected in saying in class as a professor at a state university that I would not be protected if I said them in class at the primary and secondary level. This distinction between primary and secondary and university applies to teacher speech, student speech on the basis of the existing doctrine, student newspapers. Exactly how this newspaper would be treated, I'm not sure. The Supreme Court's one school newspaper case was somewhat case specific, so we can't tell. But there is a difference between universities on the one hand and junior high schools, and elementary schools.
That's really fascinating. I'm afraid personally I would come out on the side of the kids on this because I think there are future leaders and citizens. But also in the news recently, there was something in USA Today about a young man, 13-year-old, 7th grader, who wore rosary beads outside his shirt in honor of a deceased family member. It was interpreted potentially as a gang symbol by the school. His mother alleged his free speech and free expression rights were violated. What do you think about that?
Again, the cases on student apparel, some of them dealing with gang apparel, some Nazi apparel, some sex-related apparel, some Klan-related apparel. There's never been a Supreme Court case on the issue other than just a protest armband in 1968. The lower court cases go both ways depending on particular facts, but the more often than not, the ability of school administrators to restrict is upheld at the primary and secondary level, even though not at the university level. Obviously, when it's rosary beads, there are different issues of religion and freedom of religion that might come in, but just the ability of schools to restrict student apparel that students claim to be expressive is a very frequently contested issue. If it's outside of the school, there's no question whatsoever that students and teenagers, like everyone else, can wear whatever they want. Once they're inside the school, the authority of the school administrators wins more often than not.
Another interesting case that has been in the news lately, issues of protection, allowing people to investigate terroristic activities. There was a humanitarian group that I'm sure you read about, who wanted to explore and give some advice to a group as to peaceful means of resolving disputes, because they were dealing with the terrorists. They were the ruling came down on the side that they were actually kind of aiding and abetting. What do you feel about that?
I mean, again, the Supreme Court case on this is very recent, highly controversial. I think it's important to understand, broadly speaking, two sides of the issue. One, it is in the United States, even if not in virtually every other country in the world, legal to advocate illegal action. It is okay to advocate illegal action. It is okay to advocate overthrow of the government. It is okay to advocate terrorism. The U.S. is stronger by far than any other country in the world on the protection of people who would advocate violent overthrow of the government, subject to the exception of if you're standing in front of an angry mob and say, go get them right now, that can be restricted. But short of that, advocacy of violence, advocacy of illegal action, advocacy of murder, advocacy of overthrow of the government, all of that is protected. On the other side of that, outside of, broadly speaking, the public political arena, there's a whole realm of speech that relates to criminal conspiracies, speech that relates to aiding and abetting a crime, doesn't come anywhere near the First Amendment. If I work for a bank and I say to you, maybe this is a dated example, I don't think banks have safes anymore, but if I work for a bank and I say to you, you might be interested in knowing that this is the combination to the bank safe and these are the hours when the guards are off duty. If you rob the bank, I can be prosecuted as an accomplice or aider and abetter or co-conspirator, and my free speech objection isn't going to get me anywhere. So when we're outside of the public political arena, person-to-person speech that's part of a criminal conspiracy or part of a criminal act has nothing to do, virtually nothing to do with the First Amendment. Indeed, the conspirators of the first World Trade Center bombing, going back, 15 years ago, maybe even more, 15, a little bit more years ago. Some of the people prosecuted for conspiracy for the first World Trade Center bombing were basically prosecuted for organizing the conspiracy. Nobody even took seriously a First Amendment objection, even though what the conspirators had done was encourage certain violent acts, but they'd encouraged it in private settings. They'd provided assistance in private settings. All of that is to say that on the issue that the Supreme Court just decided, on the one side, we have the very strong tradition of protecting advocacy of virtually everything, no matter how violent, no matter how encouraging of terrorism or illegal action it may be. And on the other side, we have an equally long tradition that not every use of words comes close to the First Amendment, and a whole range of non-public criminal conspiratorial activities have never been thought to raise First Amendment questions at all.
From a legal point of view, does one of the reasons what you just said obtain because it's if you incite someone, it presumes an action. I mean, is there some connection there legally?
Technically, incitement does not require an action. It presumes that you want an action to occur. But if I stand, take a local example. Suppose that at 10 minutes to 5 this past Thursday, I am standing in front of a government office, in front of a very angry mob, and I say to these people, we have had enough of government. Let's go break into the building and burn all of the records right now. Let's go. And at the moment I say let's go, the 10-minute thunderstorm that wiped out all of these trees happens, so that there's no actual act. I can still be prosecuted for that act of inciting even though there was no subsequent act. So under current law, incitement to illegal action or incitement to violence can be prosecuted if and only if there are explicit words of incitement, only if the incitement is to an act that is to occur immediately, imminently is the term of art, and only if it is likely to happen. That's a very stringent standard, which is why almost nobody these days is prosecuted for this, but the act doesn't have to actually occur.
Okay. Does the Constitution specifically mention the right to privacy, or is it implied in the Bill of Rights by the 3rd, 4th, or 5th Amendments?
It does not specifically mention it at all. Whether there is one has been controversial, and if there is one, where it comes from has been controversial. When the Supreme Court in 1965 first said there was a right to privacy in the context of a right to purchase contraceptives, Justice Douglas found it in some amorphous combination of the First, Third, Fourth, Fifth, and 9th Amendments, when in 1973 the Supreme Court decided Roe versus Wade. It found it in the Due Process Clause. It's not explicitly mentioned.
I want to come back to this. We have to take a break.
Sure.
We're talking with Professor Schauer, and we will be back to you. This is Politics Matters. We will be back to you in a moment.
What if your brother
or your husband?
What if your son came back from the service with a spinal cord injury?
In a wheelchair?
When they volunteer to serve, we expect our country to be there for them if they are injured.
For more than 60 years, Paralyzed Veterans of America has been fighting to ensure that we receive all of the benefits that we've earned.
Thank you, Paralyzed Veterans, for helping my husband.
My son.
for helping my brother.
You too can help. Visit pva.org.
Hey, what can I get you?
Do you have a chai tea?
We just have black coffee in a medium cup.
You just have black coffee?
No teas, no lattes, no espressos.
Really?
Just black coffee in a medium cup.
Well, good luck.
For thousands of Virginians with disabilities, daily life is much the same way because they have no choice in where they live or the services they receive. Tell Virginia the time for choices is now. Register your support at abletochoose.org.
Welcome back to Politics Matters. I'm Jan Paynter. We're talking today with Professor Frederick Schauer about amendment issues, and before the break we were discussing the issue of right to privacy. Professor, what is the current state of legal debate in this age of emails, internet chat rooms, Facebook, and Twitter concerning the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure, and as cited in the Fourth Amendment?
Okay, I think there are two very different issues here. A lot of times when people worry about privacy, they worry about it in the context of knowledge of or publication of information about them by, broadly speaking, non-governmental entities, whether it be credit bureaus or banks or newspapers or whatever. The privacy that is now understood to be part of the Constitution is a protection against the government and only against the government. Protection of my privacy against a bank, against any other private institution is a matter of statute. It may be a matter of common law. It's not a matter of constitutional law. Doesn't mean it's not important. It doesn't mean there are not important debates. And there are very extensive statutory, state and federal protections of privacy. But the Constitution only protects us against government and not against non-governmental entities. In terms of privacy, most of the Supreme Court decisions about privacy have dealt with abortion, contraception, and the like on the one hand, or the protection of criminal defendants through the Fourth Amendment that you quoted against unreasonable searches and seizures and the like. Most of the forms of privacy that people worry about do not involve either of those. And whether the Constitution protects against, for example, government databases is something that the Supreme Court has never touched. It hinted that there might be some protection. The hint was 20 years ago, but direct Supreme Court decisions about government databases and all of this that lots of people are worried about, again, it's pretty much a blank slate.
This is speculation, I realize, for you, but I wanted to probe a little bit more. Why do you think the Supreme Court is so reluctant to wade in?
That's a big question, but one, let me make your bigger question even bigger. It is a mistake to think that the Supreme Court deals with the most important issues of our times.
Interesting.
Most of what the Supreme Court does is important. Most of what is important is not done by the Supreme Court. If we look over the issues that are most important over, let's say, the last 2 or 3 years, it seems to me that the four most obvious are the wars in Iraq and Afghanistan, healthcare reform, financial reform, including bank bailouts and maybe even automobile company bailouts, and most recently, the massive oil spill in the Gulf. The Supreme Court has had virtually nothing to say about any of those and will not.
Thank you again very much, Professor Schauer, for being with us today. Thank you for listening to our conversation. We would like to hear from you with all questions and concerns. You can email us at info@politicsmatters.org. Thank you again. I'm Jan Paynter, and this is Politics Matters.